ways you can do that. Let's transition now to cross-examination. And I think this could be my favorite technique in trial. And rather than lay it out, let me just tell the war story. It'll make my point better. Had a case years ago in the 183rd, Jay Burnett on the bench. And my client got caught with another topless dancer snorting cocaine in a toilet stall at a topless bar. The officer who busted them was a female sheriff's deputy who was working moonlighting overtime at the bar. And the state really missed the point. You don't have standing to contest a search any place you don't have a reasonable expectation of privacy. Now, you do have that expectation in a toilet stall, but there's case law that says you give up that expectation if it's not being used for its intended purpose. You look under the stall, there's 4 legs. I don't think that's the purpose of a toilet stall. So the state totally missed it. I had no standing, but I won anyway, and here's how I did it, not on the merits. The state subpoenaed the female deputy that busted our clients. But there was a transporting deputy, real nice fellow, big old sergeant from HPD. They called HPD, he just came down and took the girls downtown. I subpoenaed him, and the state and Judge Burnett says, what do you need him for? He's not a fact witness as to the search. This is about the search. What do we need him for? I said, I don't have to tell you my strategy. So I put the female cop, the state put the female cop on the stand, and she does her thing, and it's all tone of voice, folks. I looked at her and I said, Officer, did you discuss your testimony with anyone else before you came up here and told the judge today? I made it sound like she was killing kids or something. She said, oh, no, I would never do that. Then I called the sergeant. Just change your tone of voice. Hey, Sergeant, thanks for coming down. And do you have a chance to talk about this case with the deputy? Oh, yeah, we've been out in the hall talking about it all morning long. Judge hit the roof, kicked the lady out of his court, and granted my suppression. Not on the merits. How often do you win these on the facts and the witness's credibility? You can do this in every single case, folks. Divide and conquer. It's fun, it really is. Great technique, and there's no excuse for not doing that with the state's witnesses every single time. Okay, back to cross-examination. I know half of y'all have heard this story before, but don't blow my punchline. You got guys in here who haven't heard it. You know it's coming. It's the Abe Lincoln story. Before he was president, Abe Lincoln was a criminal defense lawyer. And this story is under the headline, Don't Ask That One Question Too Much. Y'all know this one? It's a legendary story about Abe Lincoln defending a guy charged with assaulting somebody by biting off his nose. Now, the point of the story is this. It's like Vegas. When you're winning, get your money and walk away from the table. Get out of there. But isn't that the hardest thing we have to do as a lawyer? I know I have a problem with shutting up. It's not my natural position. But when you get the answer you want, shut up. Don't give them a chance to rehabilitate their case. So the story goes that Abe Lincoln, through his brilliant cross-examination, gets the one third-party witness to admit, I never saw your client bite his nose off. Now that's when you shut up. But Abe Lincoln didn't do it. He goes that one step too far and says, well, how do you know my client bit his nose off then? And the witness says, I saw him spit it out. That probably never happened, but let the legend live, okay? Anyway, practice shutting up. I know I need to practice that. Here's another fun one. I didn't think this would work. I read this in the book, The Art and Science of Cross-Examination. I was telling Steve this story earlier this week. It's like voodoo, folks. You get that runaway cop witness. You know the guy, you ask him a simple question. Was the light red or was the light green? And 15 minutes later, it's, well, you know, your client was speeding and he confessed he ran the light. He had drugs in his car and there were a bunch of other witnesses. Now, there's lots of techniques to control the runaway witness. What does a weak lawyer do? Your Honor, we would ask that you instruct the witness to be responsive to my questions. You look like a weak dog in front of the jury when you do that. And the judge is not there to help us. Try this trick. It's really cool. I would bet money this ain't gonna work. The whole jury is looking at the witness. The judge is looking at the witness. The DAs are looking at the witness. The only guy looking at you is the witness. He's running on. Give him one of these. Put your hand down. These guys have a military background. For some bizarre reason, they respond to hand gestures. I've done that now maybe 5 or 10 times. It's like voodoo. They shut up. I was telling Sean Buckley that story the other day in Fort Bend County, and he added this. That works on your own witness as well. You know, you put your client on the witness stand, and he's stinking up the courtroom. He's running on too. What do? It's like a reset button. Yeah, they shut up, start over again. Try it, folks, but don't let them see you do it. Everyone's watching the witness. Put your hand up, put it down. I promise you, it really works, okay? There are other hand gestures involved too, but I'd stick with this one. You know, one time I had a little marijuana case in Travis County for a young man who's now a Harris County criminal defense lawyer. In a rare act of discretion, I will not name him. But in Travis County, if you've worked there, the lawyers all go back to the jury room and you all hang out together so everybody hears everybody else's bullshit. And it's like, here's your turn, go. And everyone's listening to you. So I patiently wait my turn, and this chief prosecutor, it's kind of a hill country cowboy type, he looks at me and says, well, what do you want? And I said, well, you know, here's how we plea bargain in Harris County. I'll let you dismiss this case, but not until you apologize to my client and pay him back for my fee. And I usually demand the dope back, but there's so little weed in this case, we'll let you keep it. And this guy looked at me and he said, you know, in Travis County, we respond to that kind of plea bargaining with hand gestures. Do you want to see? And I said, no, sir, I can read between the lines. And then he gave me my Class C misdemeanor, okay? So I think comedy also works on prosecutors. And a lot of them don't accept it. They don't want to hear it. A lot of them bristle. And I don't care. The point is this, if they're laughing, they can't bitch at you at the same time. I'm very fond of telling prosecutors that you call my clients repeat offenders. I call them satisfied customers. Here's another one I often use. Every weed case I get, I tell the DA, you know, my clients who get drunk, they often go home and beat up their wives. My clients who use cocaine, they often go out and they rob stores. My clients who smoke weed, only thing this kid ever attacked was a refrigerator. It's a big danger to a box of Twinkies. Where's the harm to society? And the point is, it not only puts them in a better mood, it minimizes the case itself. I think it's really important because if you get these juries laughing at the case, they're liable to laugh it right out of court. And don't get me wrong, there is a point in every trial where you need to put your foot down and you need to get serious. But I have to think that if they think you're sort of happy-go-lucky and a jokester kind of guy, when you get serious, I think they take you more serious because you're not always like that. You put your foot down. And you can play both sides of that. You don't have to be all serious or all joking. I suggest you use comedy very, very sparingly because you need to convince this jury that this is very serious business. Your innocent client is being railroaded here, and there's not a lot funny about that, folks. What's funny are these Keystone Cops. Here's a great line from the Irish poet and playwright Brandon Behan. I love this. He said, I've never seen a situation so dismal that a policeman couldn't make it worse. Isn't that the truth? How many times do we see that? Okay, folks, let me give you some general speaking techniques. And I think if I could impart one thing on how to give great speeches, it's don't. Don't give a speech. Pick one guy in the audience and talk to him. Hey, Damon, how you doing? Don't give a speech. Have a conversation with the juror. Find your best juror, the one most likely to buy what you're saying, and just talk to the guy. It's a very effective technique. One speaker's technique is, if you're nervous, imagine him in his underwear. Sorry, man, I'm not going that far. But I think it's very, very important to be yourself. Find your own style. This is my style, probably isn't your style. But like Dossie said, be true to yourself because they're going to see right through bullshit. They really will. So find your style and milk your style. You can use these techniques in any style. They don't have to be one style or the other. But I think it's really important that you just talk to these people in a regular conversational manner. Here's a trick that comedians use a lot. It's called looping. And it's what I referred to earlier when I said you want to hammer this and hammer this and hammer this at every phase of the trial. I want to give you an example of looping that I stole from Kinky Friedman, an old college buddy I've gotten drunk with many times. And when you see Kinky, he's going to tell this joke every single show he has at the very beginning. And throughout the concert, he will loop back to the same punchline, but you don't need the whole setup. Again, off topic, too good a joke to walk by. I don't have a lot of clean material, so I might as well use it. Y'all know the statue of Jesus? Great joke. This is the national joke of Texas. It's about the old Texan. He's the real thing, folks. He's got the 10-gallon hat. He's got the boots. He's got the pickup truck, and he's driving out in the country, getting kind of tired. So he pulls over at this rest stop. He gets out to stretch, and there it is, a big old statue of Jesus right in the middle of that rest stop. So being a man of the Lord, he takes off his 10-gallon hat. He goes over there, gets down on his knees, and he starts praying hard. He says, folks, times are tough in Texas. He says, all my oil wells are run dry. All my ranch land ain't worth a damn. All my Cadillacs are in the shop. All my cattle's been rustled away. Times are tough in Texas. Jesus, can you help me? And as he gets up to walk away, he notices out of the corner of his eye, there's a little Mexican fellow around the back side of that statue. And he's also down on his knees, just praying for all he's worth. So the Texan, he gets kind of curious, so he takes the long way around. He sneaks up behind him and he listens. And he hears, Señor Jesús, puede ayúdame? Can you help me, Jesús? Mi esposa es muy mal. My wife, she be very, very sick. And the doctor, he tell me today that she now pregnant with our 14th child. And me, I cannot afford to feed my first 13 children. And my boss, he tell me that the plant going to close. I'm going to lose my job. Señor Jesús, can you help me? And the Texan, he hears every bit of that. He just gets him right here. So he walks up to the little Mexican fellow. He pulls out a brand new $100 bill out of his pocket, and he goes, here you go, little buddy. Now, don't be bothering Jesus with that shit, okay? Here's where your looping comes in. Go watch Kinky Freeman. Every 15 minutes, he'll look at the crowd and say, don't be bothering Jesus with that shit. You don't need the whole joke. You loop back to it. It emphasizes your point. It's very efficient because it saves time of going through it all again. Get your theme, loop it, and loop it 10 times more. Drill it into their heads, folks. I love that joke. You proud of me for working clean, Eric? Okay, folks, here's another good one. Trilogies. I believe this was Cicero, the Greek orator, who noted that people remember things in sets of threes. Trilogies. I don't know why this is. I tell my jokes in sets of threes. Make your list. Give them 10 sets of threes. Catchy stuff. Use alliteration. Use rhyming. Use anything to make it memorable. Because at the end of the trial, let me tell you something. They're not back there talking about presumption of innocence or reasonable doubt. Give them something catchy that sticks in their craw, whatever a craw is. Does anyone know? Do we have craws? I don't know. But let me give you an example of that in action. And I'm going to tell us another story about a case that I tried many years ago in front of Judge Joe Keegan's, rest his soul. This has 3 or 4 great trial tips and tricks on the way. And again, give all the lectures you want. This story will make the point better. Had a client, was 20 years old and a true habitual. This was back in the days, late 80s, when people were doing a month on the year. Guy got a life sentence, he'd do 10 months. It was great for our practices. But I had a guy that's 2 years when he's 18. He got 3 years when he was 19. Shit hit the fan. He's 20 years old, and he's looking at 25 to life. Got caught running with the hooker in the 5th Ward. He tries to get away from the police. They chase him down, beat the crap out of this guy. Now, when the cops beat the hell out of someone, every time they're going to charge him with resisting arrest or assaulting a police officer. That's what they have to do to cover their own asses. You can't just beat a guy up because he needed an ass kicking. You did it because you had to protect yourself. So what I did, unbeknownst to the state, who never checked the court file, is I put the cops' medical records in the file with self-proving affidavits. I think it's 2 weeks, 14 days in advance. You have to have them on file. I think now you have to give the state copies. I don't think you had to at the time, but here's where it gets fun. I spent an entire half a day in trial cross-examining these 2 cops. How many times do you punch my client in the left eye? How many times do you punch him in the right eye? How many times do you punch him in the nose? I named every body part known. And when the DA and Judge Keegan's are objecting, move along, I just turn the record over. How many times did your partner punch him in the nose, in the eye, in the ear, in the jaw? I must have asked this 400 times, but what I'm trying to suggest is that you need to play to their natural propensity to lie. They're gonna lie. They wanna lie. They're trained to lie. They're born liars. And that's a boon for us, folks. Our biggest nightmare is an honest cop. Those guys will clean your clock. But when a cop is lying, it gives us a chance to catch him lying. You want to turn the trial from about how guilty your client is to what a liar the cop is. And boy, did they play my cards during this trial. I had him on record over 400 times saying, we never hit him, we never hit him, we never hit him. Then I pulled out the medical records, put them all on posters. I had 3 active verbs. In their patient admission forms, they said we injured our fists while striking a suspect. In the nurse's admission form, they had hitting a suspect, and the doctor had punching a suspect. We never hit him under oath 400 times, and here I had 3 different verbs of how they beat the crap out of the guy. So here's a joke you might want to use in trial. I looked at that jury and I said, ladies and gentlemen, this is an aggravated assault of a police officer case. And that's exactly what happened. Long pause. Let them think for a minute. They're going, did he just say his client's guilty? I said, that's right. My client aggravated the police, so they assaulted him. And that's exactly what happened in that case. But then you got to ask yourself, great, the ag assault went away. What about the 25 rocks of crack in the guy's pocket? That was a lot tougher. And I got to thank Mr. David Cunningham for what I call the candy bar metaphor. Here it is, folks. I'm really proud of this one. I've been looking for years to use it again. You need 2 cases tried together to use this. In my closing, I got up there and I said, folks, during the break, you might get a little hungry or thirsty, so if you want to, there's a snack bar downstairs. You might want to go get yourself something to eat. But let me ask you, what would you do if you got yourself a Snickers bar and you started to unwrap the top of that and you're just about to take a bite and you look down and sitting on top of your Snickers bar